What is Lawrence M. Friedman's A History of American Law, 1973? Lawrence M. Friedman's A History of American Law, 1973 is a sweeping, accessible, and deeply influential account of how American law took shape from the colonial era to the modern age, written not as a parade of isolated cases but as the living biography of a society. In plain terms, it is a story about how Americans made law, and how law in turn remade Americans, across centuries of settlement, revolution, commerce, conflict, reform, and rights-conscious politics. Friedman, a leading scholar who helped anchor the movement of legal history within broader social history, set out to answer a deceptively simple question. Why is American law the way it is? His answer resists heroic myths and technical tunnel vision. He treats law as a social product. Rules and institutions do not float above life. They grow out of commerce, faith, family, slavery and abolition, immigration and urbanization, technology and communications, war and peace, and the unending American habit of organizing, litigating, compromising, and legislating. In this telling, statutes and decisions are evidence of deeper structures: the business cycle, the spread of markets, shifting class relations, regional cultures, the rise of professions, and changes in moral sensibilities. The book's signature phrase is legal culture, meaning the bundle of ideas, expectations, habits, and incentives that shape both how ordinary people use law and how elites write and enforce it. That concept gives the narrative coherence. American legal change is neither pure accident nor abstract logic. It is culture at work. A bit of origin story. Before Friedman, much legal history read like an annotated table of contents for casebooks or a triumphal march of constitutional doctrines. Friedman invited readers into a wider room. He gathered court records, statutes, newspapers, trade journals, legislative debates, economic data, and the everyday detritus of legal life. He showed how seemingly dry reforms, such as codifications or changes in pleading, reflect and reinforce deeper shifts, such as the growth of markets and the professionalization of the bar. The 1973 edition, the one that made his name well beyond law schools, is the foundational map. Later revisions refined and extended the story, but the original spirit remains: panoramic, brisk, ironic without cynicism, and democratic in its instincts. Let us walk the arc that Friedman draws, pausing to fix landmarks. The earliest chapters begin in the colonies, where English law traveled not as a sealed chest, but as a set of tools to be adapted. Settlers brought common law forms, but the soil changed the crop. Sparse populations, scattered towns, and urgent needs produced a legal order that was at once familiar and improvised. Colonial assemblies legislated freely, juries enjoyed broad sway, and local courts mixed law with community norms. Religious establishments mattered, especially in New England, yet even there the practical needs of trade, inheritance, and land distribution forced compromises between theology and custom. What emerged was not a carbon copy of England, but a provincial common law with a distinct American accent. Revolution and nation-making did not wipe the slate clean. They redrew the lines. The new constitutions created written frameworks that placed legislatures near the center, marked off zones of rights, and made courts guardians of texts. The federal Constitution, with its allocation of powers and its Bill of Rights, did more than design institutions. It reframed political argument as constitutional argument. Meanwhile, the young nation's most pressing legal work concerned land. Titles had to be quieted, boundaries surveyed, and westward expansion processed into law. The law of property, especially in land, was the skeleton on which muscles of credit and markets could hang. Recording systems improved, conveyancing surged, and the American penchant for subdividing, mortgaging, and speculating created a legal environment in which land became both home and commodity. The 19th century, in Friedman's account, is the great age of private law and the maturing of the legal profession. Bar associations formed, law schools multiplied, and appellate courts turned out opinions at an accelerating pace. This was also the century of enterprise. Corporations spread from canals and turnpikes to banks, factories, and railroads. Legislatures experimented with general incorporation statutes, lowering the transaction costs of organizing collective capital. The corporate form, with limited liability and entity status, became the locomotive of development. Courts and statutes adapted to the demands of a market society. Contract doctrines leaned toward enforcement of bargains. Rules of negotiable instruments and secured transactions lubricated credit. Bankruptcy laws cycled between severity and leniency as economic crises tested political tolerance, and tort law began its long evolution from a patchwork of writs toward a system for managing the costs of accidents in an industrial age. Here, Friedman's social historical lens pays dividends. He does not merely report that tort law grew, he shows why. Railroads killed and maimed, factories injured workers, cities created new hazards. Judges, caught between sympathy and growth priorities, calibrated doctrines of negligence, contributory fault, assumption of risk, and duty. The pattern, he suggests, is compromise. Enough liability to spur safety and compensate some victims, enough restraint to avoid strangling nascent industries. Insurance quietly enters as co-star. The spread of liability and accident insurance softened the harshness of all or nothing rules and laid groundwork for a modern risk-spreading economy. Family law and inheritance also trace social change. Coverture slowly loosened as married women's property acts chipped away at a doctrine that had merged a wife's legal identity into her husband's. Divorce, rare and stigmatized in early periods, became more accessible as states liberalized grounds and as mobility allowed migratory divorce, a social legal phenomenon that made moralists fume and litigants strategize. Illegitimacy rules softened. Adoption gained legal definition. And the household's economic basis shifted as wage labor pulled members into markets. Wills and intestacy mirrored values. Primogeniture withered. Equality among children rose. Testamentary freedom expanded. And charitable trusts grew with elite philanthropy. Public law did not sleep. The antebellum period is impossible to tell without slavery, and Friedman does not look away. Southern law hardened around the defense of chattel slavery, building codes of control and a property ideology that pervaded courts and statutes. Northern resistance ranged from personal liberty laws to abolitionist agitation. Federal compromises temporarily papered over conflict, but the law could not quarantine politics. The Civil War shattered the frame. Reconstruction amendments recast citizenship, rights, and federal power. Yet Reconstruction's legal promise was unevenly enforced, and the ensuing decade saw regimes of segregation and disenfranchisement take legal shape. Friedman's tone here is steady but somber. Law can write promises, but culture and power determine whether ink becomes life. The late 19th and early 20th centuries are, in Friedman's map, the age of regulation and the long contest over laissez-faire constitutionalism. On one side stood reformers pushing factory inspection, food and drug safety, workers' compensation, pure water, and public utility oversight. On the other stood courts wary of what they saw as threats to liberty of contract. The famous Bakery Hours case from New York becomes emblematic. The judiciary's struggle to decide when the police power can limit private bargains for the sake of health and welfare. Friedman resists caricature. He shows that even in the so-called Lochner era, much regulation survived. The pattern is mixed and pragmatic rather than doctrinaire. Meanwhile, antitrust law emerged to tame industrial concentration, and public utility doctrine recognized that some enterprises, by virtue of monopoly or necessity, required special oversight. The administrative state began to coalesce as commissions and agencies took on specialized tasks ill-suited to generalist courts. Criminal law and procedure track another story, from community-based enforcement and public shaming to professional policing, prosecutorial discretion, and penitentiaries. The 19th century's penitentiary movement, infused with hopes of moral reform, ran aground on overcrowding and brutality. Yet the institutional framework of prisons and probation endured. Policing professionalized unevenly. Cities developed patrol forces. Detective work and forensic methods grew, and the modern prosecutor became a central figure. In the 20th century, constitutional criminal procedure flowered. Exclusionary rules, counsel rights, interrogation safeguards, and equal protection inflected reforms reshaped the landscape. Friedman characteristically ties these shifts to politics, urbanization, media, and fears of disorder as much as to doctrine. Law responds not only to reasoned argument, but to headlines and moods. Procedure and courts matter too. The American penchant for litigation is not pure stereotype. Procedural reformers campaigned against archaic pleading forms, codification simplified practice in many states, and federal procedural rules in the 20th century sought a model of notice pleading and liberal discovery designed to get cases decided on the merits. Jury trial remained an icon and a reality, though the rise of settlement and plea bargaining shifted much adjudication off-stage. Class actions, mass torts, and complex litigation would later stretch courts in ways the 19th century framers of rules did not fully imagine. But Friedman's early chapters already show the seeds: consolidation, equity powers, and managerial judging. Education and the bar are pillars of the story. Apprenticeship gave way, gradually, to law schools. Proprietary schools battled university-based models. Case method pedagogy rose with the influence of casebooks and Socratic classrooms, and bar examinations and character requirements crystallized a professional gatekeeping regime. Professional identity, in Friedman's telling, is not merely about competence, it is about status, monopoly, and politics. The bar lobbied for court reforms, fought with other professions for jurisdictional turf, and mediated between elite and popular legal cultures. The 20th century's middle decades bring the New Deal and a constitutional transformation. Economic catastrophe undermined faith in courts as guardians of laissez-faire and boosted claims for national power to manage markets and welfare. Agencies proliferated, administrative law grew teeth, and judicial review recalibrated toward deference on economic policy while sharpening scrutiny on rights. Labor law recognized collective bargaining. Social insurance schemes like unemployment and old age pensions knit a basic safety net. Securities laws injected transparency into capital markets. The conceptual center shifted from formal liberty of contract toward recognition of structural inequalities and the need for public ordering. Friedman stresses that the shift was prepared by decades of intellectual and political work. It was not a sudden conversion, but a cumulative rebalancing. Civil rights and civil liberties cresting in the mid-century illustrate another of Friedman's points. Change comes from coalitions, tactics, and institutions as much as from principle. Movement lawyers developed test cases. Social science research entered the courtroom. The press amplified stories of injustice, and the federal government, for reasons moral and geopolitical, invested more in rights enforcement. School desegregation cases, voting rights reforms, fair housing and employment statutes, and criminal procedure revolutions. None of these were inevitable. They required organized campaigns, sympathetic judges, and repeated legislative pushes. Friedman's sensibility remains pragmatic. Celebrate gains, but notice that every victory rearranges incentives and creates counter-movements. Law, being a public resource, attracts users of many kinds. By the late 20th century, which the 1973 edition already prefigured, litigation culture had both expanded and matured. Product liability grew, often shifting away from negligence towards strict responsibility for defects. Environmental law blossomed with statutory regimes that married scientific monitoring to citizen suits and agency enforcement. Consumer protection moved beyond caveat emptor, with disclosure duties, warranty law reforms, and unfair practice prohibitions. Family law continued to evolve with no-fault divorce, recognition of broader parental roles, and debates over reproductive autonomy. Criminal justice absorbed waves of reform and backlash. Sentencing structures and incarceration rates rose dramatically, and constitutional constraints mingled with legislative tough-on-crime agendas. Throughout, Friedman urges readers to look beneath doctrinal rhetoric to social drivers: suburbanization, demographic shifts, crime fears, economic restructuring, and the growth of technocratic management. What gives the book its staying power is not merely breadth, but the patterning intelligence behind it. Friedman's legal culture is not a mysterious essence. It is a working model for how to connect the dots. Consider three recurring themes. First, the market as engine and solvent. American law both enables and disciplines markets. Property regimes make assets secure and tradable. Contract law makes promises enforceable. Corporate and financial law mobilize capital. But markets generate externalities, shocks, and inequalities, which in turn produce regulation, liability, and redistribution. The oscillation between freedom and control, between innovation and risk management, runs through every chapter. Second, the state as organizer and umpire. Whether weak or strong, fragmented or coordinated, government is always present. Legislatures respond to lobbies and crises, courts arbitrate conflicts, and at times, set agendas. Agencies gather expertise and translate policy into standards. Federalism complicates the picture by creating overlapping jurisdictions that sometimes compete and sometimes collaborate. The American taste for decentralization tempers centralized authority, but also opens space for experimentation. Third, pluralism and conflict as normal conditions. The United States is not a unitary legal culture, but a federation of cultures that change over time. Regions, classes, races, religions, and professions bring different expectations to law. As a result, legal evolution is noisy. Reform rarely proceeds in straight lines. Doctrines advance, retreat, and tack. Statutes compromise and then are amended. Constitutional meanings thicken by accretion. Friedman's tone refuses despair. The noise is the music. A dynamic society necessarily produces a dynamic law. The book is also notable for its method, the craft of telling a legal story without turning it into either hagiography or mere sociology. Friedman is generous to predecessors but unafraid to criticize. He respects courts while reminding readers that judges are not priest-kings, but officials embedded in cultures, trained in particular schools, answering to constituencies and consciences. He admires reformers' courage, yet stays awake to unintended consequences. He has a historian's allergy to monocausal explanations. The rise of the corporation is about more than statutes. The shift in tort law is about more than a single case. The transformation of constitutional law is about more than a single justice. The structure of his chapters mirrors this method. Each domain, property, contract, tort, family, crime, public law, gets a narrative that switches between doctrine, institutions, social context, and examples, always returning to the questions: who uses this law, for what purposes, with what payoffs, and at whose cost? A signature contribution is the demystification of court opinions. Rather than treating them as self-evident truths, Friedman reads them as artifacts of their times. He asks, what problems did judges think they were solving? What interests and ideologies shaped the available answers? How did legal forms constrain or enable particular solutions? And how did later courts and legislatures react? This approach does not reduce law to politics. It rescues law from the illusion that it floats above politics. The result is both more honest and more interesting. it becomes possible to appreciate craft, courage, and creativity without pretending that the players were omniscient or apolitical. Critiques of Friedman's project often come from two directions, and acknowledging them sharpens appreciation of the book. On one flank, some doctrinal scholars complain that the canvas is too broad, the brush too thick. Nuance of reasoning, doctrinal chains, and intertextual debates get compressed. On the other flank, some social historians argue that, for all its breadth, the story could go further in centering marginalized voices, especially women, indigenous peoples, and non-white communities, whose legal lives were often governed as much by informal orders and local practices as by appellate opinions and statutes. Friedman anticipated parts of these critiques by integrating economic and social history and by knitting together high doctrine with low practice. Later editions and allied scholarship have extended the inclusions. But the basic wager of the book stands. To understand American law, you must look through a wide lens and ask how institutions and rules relocate power across society. The prose deserves a word. It is clean, wry, and purposefully unsentimental. Metaphors are modest, the pace brisk, the judgments measured. There is humor without mockery, sympathy without sentimentality, and a repeated effort to remind readers that, in matters of law, absolutes are rare. Values collide, interests bargain, and people adjust. The book's readability is not an ornament, it is a teaching strategy. Complex ideas need not be cloaked in jargon. In this sense, the book's success helped expand the audience for legal history, drawing in lawyers, historians, political scientists, and general readers who wanted to understand how a nation famous for both litigation and liberty came to be as it is. To see Friedman's framework in action, consider a handful of emblematic episodes. When the Supreme Court announced that federal courts sitting in diversity must follow state substantive law, it did more than rearrange citations. It acknowledged plural legal cultures within a federal union and reined in the centralizing gravitational pull of federal common law. When the court later upheld programs that reorganized the economy during crisis, it recognized shifts in the balance between freedom of contract and coordinated economic policy. When mid-century justices expanded criminal procedure rights, they did so in a context of urbanization, professional policing, and a growing national media. When tort law shifted toward strict product liability, it responded to mass production, national distribution chains, and the difficulty of proving negligence in complex systems. Each doctrinal turn has a social backstory. Each social backstory leaves fingerprints on doctrine. One of the most provocative aspects of Friedman's book is its quiet insistence that law's center of gravity lies not only in courts, but also in legislatures and agencies. The American imagination often turns to judicial heroes and villains, but statutes, regulations, and local ordinances form most of the living legal environment. Friedman tracks the rise of the administrative state not as a fall from constitutional grace, but as a practical adaptation to modern complexity. Regulation of food and drugs, securities markets, labor relations, public health, and the environment requires ongoing monitoring, expertise, and flexible tools. Courts remain important, but as partners and reviewers rather than sole authors. Another fruitful thread is federalism as a laboratory and battleground. State diversity allowed for experimentation. One jurisdiction tried no-fault divorce, another embraced workers' compensation early, a third liberalized corporate charters, a fourth pioneered consumer protection. Successful models diffused. Failed ones warned others off. At the same time, diversity produced conflicts and inequalities, prompting national interventions through constitutional rulings or federal statutes. Friedman resists easy judgments. He underlines both the creativity and the cost of a system that distributes power widely. What, then, are the book's core lessons for readers trying to make sense of American law today? Start with humility about causation and about heroes. No single case, legislator, or theory explains a century-scale evolution. The building of legal regimes is collective work, shaped by millions of choices. Continue with attention to incentives. Rules do not only express values, they channel behavior. Reformers must ask how new rules will be used, by whom, with what strategic adaptations. Add a historical appetite for compromise. Because American law sits in a pluralist political economy, many outcomes are negotiated balances rather than pure principle. That is not necessarily a vice. It is often how freedom and order coexist. Friedman also teaches how to read legal change ethically. He does not reduce everything to interest group maneuvering. Values matter. Moral ideas about equality, dignity, safety, and fairness drove movements for abolition, labor rights, consumer protection, civil rights, and more. The legal system incorporated these ideas imperfectly, sometimes betraying them, sometimes translating them into durable institutions. To measure progress, one must hold the system to its stated commitments, counting gains and naming losses with candor. The book's tone of engaged realism invites that kind of evaluation. Finally, the book reminds us that legal history is not nostalgia. It is a toolkit for present work. If we know how past Americans handled technological shocks, public health crises, concentration of economic power, urban crime, and contested moral questions, we are better prepared to choose wisely now. The patient accumulation of institutions, precedents, and practices gives us a repertoire. We can choose from it, revise it, or reject parts of it, but only if we know what it contains and why it took the shape it did. A few curiosities to end on. Friedman delights in small details that reveal big patterns. The spread of recording offices and how they made land more easily tradable, the mundane but transformative effect of standardized forms, the rise of professional malpractice suits as a signal of consumer empowerment and changes in trust, the shifting footprint of legal publishing and how the availability of case reports affected doctrine's circulation, the long shadow of insurance in the shaping of liability and safety, and the quiet power of procedure, through discovery and class actions, to move disputes from the private to the public sphere. He is also attentive to the geography of law, how frontier regions, ports, factory towns, and corporate headquarters each imprint distinct rhythms on local legal cultures. In sum, A History of American Law, 1973 became a classic because it offered a usable past. It told lawyers that their craft sits inside a wider social world. It told historians that law is not a remote language, but a vital dialect of power and value. It told citizens that the rules they live under were made by people like them, under pressures not so different from those of today. Its central image is not of granite courthouses, but of a restless nation, building and rebuilding frameworks to house its conflicts and hopes. The story does not flatter everyone, and it should not, but it does honor the capacity of a democratic society to learn, adapt, and argue its way toward forms of order that leave more room for dignity and flourishing. If you pick up the book with these guideposts, you will find not only a survey, but a set of habits. Connect doctrine to life. Notice the incentives. Ask who benefits and who pays. Read texts against their times, and keep a running account of how legal culture both reflects and shapes the world. That, more than any single chapter, is Friedman's enduring gift. Above, you have more videos to keep learning law. Remember to give us a like and subscribe.